Legal Pond.
Welcome to today's episode of the Legal Pond. Today's video is going to cover Terms of Contract 2. Terms of Contract 2. I told you from the previous video on Terms of Contract that because of how long the topic is, I am going to break it down into two. So today's episode will cover Terms of Contract 2, which will focus on standard form contracts and exclusion clauses. Let's get started.
The Legal Pond.
Welcome back. So as I said early on, today we are looking at standard form contracts and exclusion clauses. Now, what is a standard form contract? When we say a contract is a standard form contract, it is that contract whose terms is mostly prepared by one party to the contract, and then the other party is asked to either agree or ignore. So those type of contracts is known as a standard form contract. Now, most of the time, this standard form contract comes with exemption clauses, which may be exclusive in nature or limited in nature. So what it means is that they may insert some clauses in the contract, which suggests that the stronger party or the party that prepared the terms will be excluded from some kind of liability when there is a breach. So if there is a term in the contract which excludes a party to the contract from liability, is that term a valid term? Is that term a good term? That is what we are going to look at here. Now, the basic rule is that because standard form contracts are mostly prepared by one party for the other party to agree or reject, exclusion clauses which are included in standard form contracts are not automatically binding. So for an exclusion clause to be binding as against the party who signs it, it depends on two major factors. The first thing is that the exclusion clause must be incorporated into the document as a term of the contract. And then two, that exclusion clause must cover the liability in question. For an exclusion clause in a standard form contract to be considered as a valid term of that standard form contract, for it to be binding, the conditions are two. They are that one, the exclusion clause must have been properly incorporated into the standard form contract as a term. And then two, the exclusion clause in question must cover the liability in question. What does these 2 points mean? So I'm going to pick them one after the other and then explain them. What does it mean to say that the exclusion clause must be incorporated into the contract as a term? This means that the exclusion clause must be fixed into the contract. The person who seeks to rely on the exclusion clause must make sure that that exclusion clause which excludes him from liability is being fixed into the contract, is being incorporated into the contract. Now, there are three major ways by which an exclusion clause or an exemption clause or even a limitation clause can be incorporated into the contract. One of these ways is by signature. Two, by notice. Three, by course of dealing. The exclusion clause can be incorporated by way of signature. It can also be incorporated by way of notice, and it can also be incorporated by way of course of dealing. What goes into each of these methods of incorporating the exclusion clause? One, by signature. If the standard form contract is one that requires the weaker party or the other party to append his signature to it, you and I know from our previous discussions that once a person signs a document, that person is bound by all the terms in the document. So what it means is that if there is an exclusion clause in that document and the person signs it, that signature incorporates that exclusion clause as a term of the contract. So let's look at a case like Lestrange versus F. Graucoup Limited. Lestrange versus F. Graucoup Limited, where this woman purchased a cigarette vending machine. And then in that particular transaction, they signed a document. And the document indicated that any form of implied or express condition is excluded. So the cigarette machine failed in performance. It proved to be faulty after the sale. But then this woman wanted to enforce an implied condition as to quality of that machine. But the court did not allow her on grounds that she had signed to the exclusion clause, which were part of the standard form contract. There is this case of Ignusa versus DHL Express Limited. Now, this case involved a professional who wanted to deliver some checks to America through DHL Express. When he presented those checks to the airline for them to deliver it to America on his behalf, they gave him a document to sign. And that document contained a limitation clause which says that in case of any liability or in case of loss of the goods being delivered or being transported, the company is only going to be liable for $100 fine. So that was a limitation of their liability. It was a limitation clause. Now, this man signed the document after reading, and then he realized that not all the checks arrived. So he wanted to sue them for negligence and for breach of their contract. But the court prevented him from suing the company or holding them liable for the loss because he has appended his signature to the exclusion clause, which was part of the terms. Another way by which an exclusion clause or an exemption clause or even a limitation clause in a standard form contract can be incorporated into the contract is by way of notice. Now, the law, as stated in the case of Parker versus Southeastern Railways, states that where an exclusion clause is supposed to be given or is supposed to be incorporated by way of notice, then the party that seeks to rely on the exclusion clause must make sure that he had given a reasonable notice to the other party of the exclusion clause. Now, what will make the notice a reasonable one? There are rules regarding that. The first rule is that for the notice to be reasonable, it must have been given before the contract was concluded. So let's look at the case of Ole versus Marlborough Court, where this couple went to a hotel to book a room. Now, they booked the room at the reception where they were given receipts, and then they entered their room. Now, when they entered their room, at the back of their door, there was a notice which stated that if in case they lose any belongings of theirs, the hotel is not going to be liable. Now, they lost some of their belongings and then sued the hotel. And the hotel wanted to rely on the exclusion clause in the contract, which says that the hotel will not be liable for any loss of their belongings. But the court said that no, this notice is not reasonable because it was given after the contract has been concluded at the reception. The court said that the contract between the hotel and the lodgers were concluded at the reception where they paid their money and were given receipts and were allocated their room. So the notice was given after they have gotten to their room. That was after the formation of the contract. So a reasonable notice must be given before the contract is concluded. Another thing is that for a notice to be reasonable so as to be able to incorporate an exclusion clause, that notice must not be far-reaching. What it means is that the more onerous the exclusion clause, the greater the degree of notice you must give. So the notice must not be far-reaching if the terms of the exclusion clause are onerous in nature. So for instance, in the case of Taunton versus Shoe Lane Parking Limited, there was this parking lot where people go there to park their cars. And then this man went there to park his car. Now, before he got to the premises, there was a machine there where he inserted money and then they printed a receipt for him as payment for him parking his car. And on the receipt, they stated that the receipt is subject to terms and conditions written at the premises. And then at the premises, on the pillars, it was written that the company was not liable for any injury suffered by customers. And they even stated that the cars which are parked there are parked at the customer's own risk. Now, after everything, this customer suffered an injury, personal injury, and he wanted to sue them. The company now wanted to rely on the exclusion clause, but the court did not allow them on grounds that, one, the contract was concluded before the notice was given. And then two, looking at how onerous the exclusion clause was, they should have given a more reachable notice than placing them on the walls and then giving the direction at the back of the receipt. That wasn't enough. So the court did not allow it. Another thing is that a reasonable notice must be clear and unobliterated. So if the notice has been given, but then the notice is such that it cannot be read, it is not clear, it is even ambiguous, then that notice is not a reasonable notice. Therefore, the exclusion clause will not be considered as properly incorporated as a term of the contract. So you look at the case of Richardson, Spence, and Co. versus Roundtree, for instance. This man bought a seat in a ship, but then in the ship, he was given a receipt, and the receipt contained an exclusion clause, which limited the liability of the ship owners to $100. But that same exclusion clause was being obliterated with stamps with a red ink. So even if you want to read it, it will be difficult for you to read it and have a clear picture of what the exclusion clause is. Now, the law is that a notice of an exclusion clause must be clear and unambiguous and need not be obliterated. You may also look at the case of Chappington versus Barry UDC. Another way by which the exclusion clause can be incorporated into the terms of the contract is by way of course of dealing. Now, what this means is that if the parties have a special course of dealing, such that anytime they have to deal, there is this exclusion clause that applies, then the law is that even when that exclusion clause is not stated in a particular transaction or on a particular occasion, that exclusion clause will be considered as a term of the contract. So let's assume I am a mango farmer, and then every time I harvest my mango, I sell it to you. But then anytime I sell it to you, there is this clause that says that anytime I supply the mango to you and then 5% of them are destroyed, you are going to deduct 100 Ghana cedis from my money. And then anytime we enter into the transaction, this clause is there in the written document. Now, if it happens that one of these days we do not use the written document, but then it happens that the mangoes are destroyed, the law is that you can rely on that exclusion clause because it is the way we have been dealing. So exclusion clause can be incorporated by way of course of dealing. Now you look at the case of Holier versus Rambler Motors. Now, for an exclusion clause to be incorporated by way of course of dealing, then the law is that the parties must have dealt with each other in a regular and consistent manner. So the test is that there should be regular dealing and consistent dealing. So it should be that at every point in time, that is what you do. And then two, the course of dealing must be consistent in nature, such that there are no breakages within your dealings. These are the things that makes something a proper course of dealing for the purpose of incorporation of an exclusion clause. So you look at the case of Holier versus Rambler Motors. There is this man who is the plaintiff who have been repairing his car with the defendant's mechanic shop. And then anytime he goes there to repair his car, there is this invoice that he signs that is issued to him. And then the invoice relieves the company from liabilities which is caused to the car by a fire. So it happened that the last transaction that they had was not written, it was oral, and then the car caught fire. So the company wanted to rely on the exclusion clause to escape liability. But the court said that they have only dealt with that thing for 5 years. And then in that 5 years, it has happened for 5 times. So 5 times is not consistent and regular enough for it to be a course of dealing. Therefore, Rambler Motors was not allowed to rely on the course of dealing because the court said it was not, to their mind, it was not regular and consistent. So what it means is that for something to be regular and consistent is a question of fact. It will depend on the case in question. So that is how the exemption clause, being it an exclusion clause or a limitation clause, can be incorporated into the contract. Now, the second thing that will make an exemption clause to be binding as a term is that after it being incorporated, it should cover the liability in question. What it means is that the exclusion clause that has been stated and the breach that has happened or the liability that has arisen must be connected, must be said that the exclusion clause was one that covered the liability that has happened. So let's assume there was an exclusion clause that was excluding me from negligence. But then what I have done is not negligence, it is intention. What it means is that the exclusion clause doesn't cover it. So at that point in time, the exclusion clause cannot be considered as a term that I can rely on. That is what it means. Now, what are the rules that guides the court to come to the conclusion that the exclusion clause covers the liability that has happened? One of the things that the court uses is what we call the contra preferentum rule. Now, the contra preferentum rule says that anytime the court realizes that the exclusion clause that a party seeks to rely on is ambiguous, it has more than one meaning, it's such that you cannot say what it is or you cannot tell what exactly it is, then the court will interpret it to suit the party that is weak. In other words, the court will interpret the exclusion clause against the party that seeks to rely on it. That is the contra preferentum rule, and it was recognized in the case of Wallace, Sons and Wells versus Pratt and Hines. You can see it in that case. Another way that the court uses to determine whether the liability in question is covered by the exclusion clause is that the court looks at the scope of the exclusion clause. Now, the law is that the exclusion clause must have a scope that exactly covers the liability that has arisen. So when you look at the case of Curtis versus Chemical Cleaning and Dyeing Company Limited, for instance, you notice in that case that the plaintiff had sent his garments for laundry services, and then he was given a receipt which stated that whenever there is damage to your item involving maybe the removal of the laces and the fabrics, we are not liable. That was the scope of the exclusion clause. So this person signed it. But then when he came back, the whole cloth was stained with dirt. She sealed them, and then they were saying that there was an exclusion clause that relieved them of liability. But the court explained that that particular exclusion clause did not have a scope that covered stains. So what it means is that the court will not interpret an exclusion clause to go beyond its scope. So that is one of the things that guides the court in ascertaining whether the liability that has arisen is covered by the exclusion clause. Again, generally, exclusion clause cannot be inserted to cover negligence. However, if in any case the parties want to insert an exclusion clause that covers negligence, then the word negligence must be used in the exclusion clause. This was noted in the case of Canada Steamship Limited versus the King. Again, exclusion clause cannot be inserted to cover third parties. Exclusion clause cannot be inserted to cover third parties. So even if you put in an exclusion clause and the person signs it, and that exclusion clause seeks to protect a third party, the court will not enforce that exclusion clause. You may look at the case of Alda versus Dixon. Again, an exclusion clause will not also cover what we call a fundamental breach. Now, when you say a fundamental breach, it is a breach that when it occurs, it changes the nature of the contract entirely from what the parties agreed upon. So let's assume we contracted for you to supply me with a laptop. You ended up supplying a school bag. That is extremely different from what we intended. And there cannot be exclusion for such a liability. You can look at the case of Nichols versus Gotts. It must, however, be noted that an exclusion clause that is too onerous in nature will not be enforced by the court, or the parties to a contract will not be allowed to rely on an exclusion clause which is too onerous. When I say it is too onerous, I mean to say the exclusion clause in question is too harsh for the parties to comply with. In that sense, the court may, by its discretion, disallow its enforcement. Look at the case of Interphoto Picture Library Limited versus Stiletto Visual Programs. Similarly, if the terms of a contract seem to be too harsh, the court will not enforce such harsh terms of the contract. So basically, these are the rules regarding the reliability on exclusion clauses, which are mostly contained in standard form contracts. The law is that, first of all, the exclusion clause must be incorporated into the contract, and then two, the exclusion clause must cover the liability in question. If you have any question, you can drop it under the comment section or contact the numbers on the screen and share with us so that we help you through it. I also encourage you to get the Legal Companion, Volume 1, and then look at the questions and answers on terms of contract. See you in our next video.
The Legal Pond.